The justice systems in Canada and the United States have a lot of similarities. Both of them originate in British common law, but there's also some key differences. And today on Don't Talk TV, I'd like to talk about three specifically that have come up in my practice a number of times. Hello, my name's Nicholas Wansbutter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. A lot of people watch American TV. I think I don't own a TV, but my impression is that almost all the television worth watching is American, and certainly all the legal-based shows are American. I'm not aware of any show based on the Canadian legal system that actually shows court the way it is in Canada. So understandably, a lot of people get their impressions of how the justice system works from American TV, and therefore people often think that the way things work in the United States is the same as how it works in Canada. There are a lot of similarities, to be sure, but there's three big differences I want to cover today. And they're ones that come up from time to time in my practice, especially in practicing criminal law, where clients think that things are in Canada the way they are in the United States, and then they're quite upset or frustrated when I explain to them that it doesn't work that way in Canada. So, number three is the most minor of them. There are no sidebars in Canada. Again, in the American legal television and movies, you'll frequently see lawyers ask the judge for a sidebar. The lawyers leave their clients at the table, they go up and have a secret conversation with the judge. That never happens in Canada. In Canadian law, especially in criminal law, the accused must be present for the entirety of their case. That includes any discussions between lawyers and the judge. Now, I think the reason sidebars are usually done is so that the jury doesn't hear legal arguments that are being made. In Canada, the jury is always excused, and then those legal arguments can occur just with the lawyers and the accused person present. The second area of significant difference is juries, when you can have them and how they're selected. In the United States, the right to a trial with a jury is enshrined right in their Constitution, and as such, you can have a jury for almost everything. You can certainly have a jury for many, many matters that in Canada you would not be able to have a jury for. In Canada, you only have the right to a jury in cases where the Crown elects to proceed by indictment. So in Canada, there's two levels of prosecution. There's summary proceedings and indictment. Indictment is when things are treated more seriously and higher penalties are available. Therefore, you also have availability of different modes of trial. Most charges under the Criminal Code of Canada are hybrid, meaning that the Crown Attorney has the option to proceed by summary or indictment. Now, in terms of jury selection, that's totally different between Canada and the United States, and perhaps if people are interested, I could do an episode a bit later about how jury selection works in Canada, but just to give you the very brief version, jury selection in Canada now, thanks to certain amendments made by the Justin Trudeau government, is essentially random. The first 12 people whose names get pulled out of the lottery-style drum that gets spun, those are your 12 jurors. In the United States, there's actually a very involved process of jury selection, and I watched the jury selection for the Derek Chauvin trial, and it's very interesting, and frankly, I would like to see Canada adopt a system like the American system. Jurors have to fill out a questionnaire ahead of time, and the lawyers can use this for the basis of further questions to learn about what the jurors' views are and will they be able to judge the case impartially. Finally, this is the number one thing that comes up in my practice. In Canada, the Queen or the state presses the charge. You don't need a complainant who presses the charge against you. You don't need a willing complainant who presses the charge. In the United States, you do. So many people think, especially in domestic violence cases where under zero tolerance, someone calls 911. Maybe it's not even someone who is a party to the relationship. Because of zero tolerance, someone goes to jail regardless of the evidence or lack of evidence that the police have. And then the client is coming to me saying, well, my wife doesn't want to press charges, so won't my charge just get dropped? Well, in the United States, it would. In Canada, it's the state, it's the police that decide whether to lay the charge and decide whether to continue with the charge. And Her Majesty the Queen is represented by the Crown Attorney. That's why they're called Crown Attorneys. They're the ones who have the sole discretion and decision of whether to proceed with a case. So I think these are some important things to keep in mind. And of course, this video isn't legal advice. If you need legal advice, call another lawyer or myself. My phone number and website are listed below. If there's show topics you'd like to see me cover, please send an email to the email address listed below or leave a comment in the comment section. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, subscribing, and following us on social media.